Over 300 January 6 defendants are facing the charge obstructing an official proceeding. It's something Ed Tarpley, an attorney who filed one of the amicus briefs, says is a case of the DOJ simply going too far.
It had never been used this way in the history of the statute.
The charge being used against 350 January 6 defendants, which could carry a 20-year sentence, is 1512 AC2. The statute, obstructing an official proceeding, was passed in wake of the Enron scandal. It focused on charging someone in the event evidence was tampered with or destroyed.
We believe that the DOJ took this statute and used it for a purpose for which it was not intended.
And now the Supreme Court is hearing arguments around this very charge. The big question is, if the Department of Justice used it against January 6 defendants, could it be used against other protesters?
Justice Gorsuch actually gave 3 or 4 examples. The demonstrators shutting down a bridge, but also what about the congressman that pulled a fire alarm in the Capitol to delay a vote? Why wouldn't that fall under the DOJ's application of 1512 C2?
So you think it's possible that the DOJ went too far in this sense?
I don't think there's any question about it.
The Supreme Court is specifically looking into the charges brought against a former Pennsylvania police officer who entered the Capitol on January 6, 2021. Joseph Fischer's attorney, Jeffrey Greene, states his argument.
The January 6 prosecutions demonstrate that there are a host of felony and misdemeanor crimes that cover the alleged conduct. A Sarbanes-Oxley-based, Enron-driven evidence tampering statute is not one of them.
U.S. Solicitor General Elizabeth Prelogger, arguing on behalf of the DOJ, said the charge should remain.
On January 6, 2021, a violent mob stormed the United States Capitol and disrupted the peaceful transition of power.
A shocking admission. An undercover video of a CIA contracting officer claimed there were FBI field officers in the crowd on January 6.
The Bureau didn't really want people knowing that they were in the crowd. Because that would be overstepping their bounds.
A little bit.
Do people know that?
Why?
Did people know that the Bureau was in the crowd?
Nope, and probably never will.
Well, let me just say, it would have been great if we had known that at the trial that we had in the fall of 2022.
Tarpley has represented more than one January 6 defendant, including Stuart Rhodes, in the first Oathkeeper trial. He said more information has surfaced after the sentences took place, including the release of closed-circuit television footage.
FBI Director Chris Wray has never fully answered the question in testimony before Congress about what FBI resources were at the Capitol on January 6th. He's never really answered the question.
But if justices do decide to overturn this charge, it could change hundreds of sentences. It could also impact proceedings in special counsel Jack Smith's case against former President Donald Trump. Tarpley says that he's optimistic about a favorable ruling from the Supreme Court. The justices will make their decisions sometime in June. I'm Natasha Sweet for Washington Examiner.